Assalamualaikum, madam. My name is Nurul Ain binti Muhammad Nur and my metric number is 076811. And I will be presenting about the case of Robin Jati anak lelaki Kadis Waran versus Lembaga Pencegahan Jenayah. This case revolves around a critical conflict between individual liberty and state security, specifically whether preventive detention under POCA unlawfully restrict freedom of movement despite being enacted under Article 149 and whether the ouster clause section 15B Clause 1, which prevents judicial review of detention order, render the restriction on freedom of movement unconstitutional. The fact of this case is the appellant were detained under the Prevention of Crime Act, which is POCA, a law enacted under Article 149 of the Federal Constitution, which allow Parliament to pass law restricting fundamental liberty, including Article 9, which is freedom of movement for national security. The appellant challenged the constitutionality of Section 15B, Clause 1 of POCA, which ousted judicial review of decisions made by the Prevention of Crime Board, except for procedural non-compliance. The appellant argued that the ouster clause violated Article 9, which is freedom of movement, and other constitutional provisions, including Article 4, Clause 1, which is supremacy of the Constitution, and Article 121, Clause 1, which is judicial power. The principles of this case are Section 15B Clause 1 of POCA barred from reviewing the merit of detention order, allowing challenge only on procedural grounds. The appellant argued this violated their constitutional right, particularly Article 9, by allowing indefinite detention without judicial oversight. Article 9 versus Article 149 conflict. While Article 149 allows restriction on Article 9, the dissenting judgment argued that total exclusion of judicial review goes too far. The majority, however, ruled that national security concerns justify limiting judicial scrutiny. Second, judicial review as a safeguard. The dissenting opinion emphasized that even under emergency power, court must ensure that detention are not arbitrary. Otherwise, Article 9, Clause 2 become meaningless. The third one, proportionality in preventive detention. Article 9, Clause 2 guarantees citizens the right to move freely throughout the Federation, but is subject to law relating to security like POCA under Article 149. Thus, Article 149 gives Parliament unlimited power to suspend Article 9 or must court still ensure the detention are lawful. The appellant argued that even under Article 149, some judicial review is necessary to prevent abuse. The government, however, contended that national security justified excluding court entirely. The majority deferred to Parliament while the dissent insisted on minimal judicial oversight to prevent abuse. The judgments of this case are divided by two, which is majority judgment and dissenting judgment. The majority upheld Section 15B Clause 1, that ruling that Article 149 explicitly allows law to override fundamental liberty, including Article 9. Matters of national security are for the executive and parliament, not court to decide. Judicial review will undermine POCA purpose, which is preventing crime without delay. Second, the dissenting judgment. The dissent struck down Section 15B, Clause 1, arguing that Article 9, Clause 2 still implies limit. Detention cannot be wholly unchecked. The basic structure doctrine, which is from Semenya Jaya case, require court to safeguard constitutional principles, including judicial review. Without oversight, preventive detention could become arbitrary, which is violating the rule of law. In the conclusion, the Robin Jati case forced us to confront the difficult balance, which is, on one side, the state duty to protect public safety through law like POCA, and on the other side, the citizen right to freedom of movement, Article 9, and protection from arbitrary detention. While the majority protects security, the dissent's warning remains crucial, which is, without judicial oversight, even necessary law can become tool of oppression. That's all from me.
Assalamualaikum everyone, my name is Nur Shazafraza binti Abaka and today I will be presenting about case of Datuk Sri Anwar Ibrahim and Government of Malaysia in another. The issue arising in this case are whether Section 12 of the Constitution Act 1983, Section 2 of the Constitution Act and Section 8 of the Constitution were unconstitutional, null, and void, and of no effect as they allegedly violated the basic structure of the Federal Constitution. The second issue is whether the National Security Council Act should have been enacted under Article 149 of Constitution instead of under Parliament's general legislative power under Article 174. And the last issue is whether the National Security Council Act infringes Article 9, Clause 2 of the Federal Constitution concerning freedom of movement. So, move to the fact of the case is the applicant, which Anwar Ibrahim, filed an original summons at the KL High Court. The applicant at the time was in prison serving his sentence. He later became and currently a member of parliament. The original summons substantially seeks a declaration to the effect that the National Security Council Act is unconstitutional. The High Court, by way of special case pursuant to Section 84 of the Court of Judicature Act, referred the constitutional question for the determination of the Federal Court. The Federal Court, by majority, declined to answer the constitutional question referred to the court on the grounds that the question were abstract, academic, and hypothetical. The case was subsequently remitted to the High Court for the determination of the original summons. Aggrieved by the decision, the applicant had filed the present application pursuant to Rule 137 of the Rule of the Federal Court and the inherent jurisdiction of the court to set aside Federal Court's decision. So, move to the legal principle in this case. First, the inherent jurisdiction of the Federal Court. The Federal Court, as we know, is the highest court, has inherent jurisdiction to prevent injustice and abuse of process, even absent statutory provisions. Second is review of own decision. The Federal Court has the power to review its own decision in cases of breach of natural justice, including violation of the right to be heard. Third, breach of natural justice. It occurs when the party is not given notice and an opportunity to be heard on critical issues such as whether constitutional questions are academic or concerning their locus standi. Fourth, requirements for review. To warrant a review, the applicant must demonstrate that the breach of natural justice resulted in grave injustice. Fifth, the impact of Federal Court decision. The High Court is bound by the Federal Court's decision under Section 85 of the Court of Judicature Act and cannot decide differently on remitted matters. So for the judgment on this case is the Federal Court allowed Anwar's application, set aside its previous decision and ordered the constitutional question to be reheard, holding there had been a breach of natural justice because Anwar was not given the opportunity to be heard on the issues before the court. That's all for me. Thank you.
Greetings, madam. My name is Legendra Heroy, and I'm going to present a case about Article 9 of the Federal Constitution. The case are Puak Kim Wei and Ketua Pengarah Immigration Malaysia and Anwar. The fact of the case, a member of parliament, Puak Kim Wei, had a valid Malaysian passport. On July 22, 2015, he was barred from boarding a flight to Yogyakarta, Indonesia at KLIA 2 due to being the focus of a police investigation under Section 124B of the Penal Code, which is action detrimental to parliamentary democracy. An immigration officers informed him that he could not exit the country. Puak sought a judicial review to obtain a declaration that the travel ban was unlawful, a certiorari order to reverse the decision, as well as special compensation and other advantages. However, the High Court rejected his application. He subsequently appealed to the Court of Appeal. The constitutional issues arise from this case are pertaining Article 5, protection of personal liberty, whether the right to travel overseas falls under personal liberty. Secondly, Article 8, equality before the law, whether the decision to bar Puak was discriminatory or unequal. Article 9, freedom of movement, whether the right to leave Malaysia is part of the constitutionally guaranteed freedoms under Article 9. Lastly, Article 9 Clause 2 provide that Parliament may impose restriction on freedom of movement for security, public order, health, or punishment for offences. There are few legal principles on this case, which is personal liberty, Article 5. Personal liberty covers protection against unlawful detention, not the right to travel abroad. This was reaffirmed in the case of Government of Malaysia and Low Wai Kong, 1979, which established that there is no constitutional entitlement to travel abroad or to obtain a passport. Moreover, freedom of movement, Article 9. The right to move within Malaysia is protected under Article 9, but this does not extend to the right to travel internationally. Traveling abroad is considered a privilege, not a fundamental right. Thirdly, Parliament's power under Immigration Act 1959/63. The Director General of Immigration is empowered by Section 3 Clause 2 to manage all matters related to immigration, including barring individuals under investigation from leaving the country. Section 59A of the Immigration Act prohibits any form of judicial review, except in cases of procedural non-compliance. Lastly, judicial review. Judicial review is limited by Auster's clauses. Unless there's a procedural breach, poor complaint did not satisfy the ground for challenging the decision procedurally. The court decision on this case are: the appeal dismissed with cause. The Court of Appeal held no constitutional right to travel overseas. Issuance of a passport is a privilege, not a right. The Director General of Immigration acted within his jurisdiction under Section 3 Clause 2 of the Immigration Act. The ban was legitimate and not perpetual. It was tied to an ongoing criminal investigation. Even if considered a constitutional right, fundamental liberties are subject to lawful restriction, not absolute. The court reaffirmed the conservative interpretation of Articles 5 and 9 regarding travel overseas. That's all from me based on this case. Thank you.
Hi and Assalamualaikum. My name is Shazarida binti Samdin. Number entry is 076726. Now we are discussing of the case of Maria Chin Abdullah against Ketua Pengarah Immigration and another. And the issue is, we got four. And the first one is whether Article 5 Clause 1 include the right to travel abroad. And the second one is whether the Director General of Immigration has authority under Section 3 Clause 2 to impose a ban. And the third one is whether Section 59 and 59A, which exclude judicial review, constitutional. And the fourth one is whether judicial review can be excluded by law, considering under Article 4 Clause 1 and 121 Clause 1. And for legal principle, we got three. And the first one is dissenting by Tengku Maimun, the Chief Judge, that the travel is part of personal liberty. And ouster clauses are unconstitutional. And the third one is procedural fairness was denied. And the next one is majority by Abdul Rahman Sebli, the Federal Court Judge, that travel is not a right. Ouster clauses are valid, and ban was invalid due to misuse of circular. And the last one is concurring by Mary Lim, the Federal Court Judge, that ban was unlawful and procedurally was unfair.
The last one is the Federal Court's decision, which is all judges agree. The travel ban against Maria Chin was unlawful. The Director General of Immigration had no legal power under the Immigration Act or any other law to impose the ban. It is because the reason given was that she demeaned the government, which is not a valid legal offence. Maria had a valid passport and no law allows ban travel for such a reason. The second one is majority decision, which is most judges agree. Section 59 and 59A Immigration Act that are constitutional. Section 59 provide that Immigration does not need to inform or consult a person before banning travel. Therefore, Section 59A provides that courts only can review if procedure were followed, not the merits of the decisions. The majority said Parliament has power under Article 121 Clause 1 to limit courts jurisdiction, so this section stands. The third one is dissenting opinions, which some judges disagree. Judges Tuku Maimun and Nalini said that Section 59 and 59A are unconstitutional. It is because they violate Article 4, Clause 1, which is supremacy of Constitution, and Article 121 Clause 1, judicial power. Judicial review is a basic feature of the Constitution, which is Parliament cannot take it away. The right to travel is part of personal liberty under Article 5 Clause 1. Many marriage without a legal basis, or the right to be heard was arbitrary and unjust. And demeaning the government is not a legal offence and cannot justify such a ban.
Assalamualaikum warahmatullahi wabarakatuh. My name is Wan Arisham Wan Asim. My metric number is 079162. Assalamualaikum everyone. Today I will be representing a landmark case, Salva Vinayagam and Timbalan Menteri Dalam Negeri. First, the fact of the case. This case involved a man, Salva Vinayagam, who was detained for 2 years under the Dangerous Drug Act for alleged drug trafficking. The key issue was that his detention under the preventive detention law, but he acted alone. The law, however, only applies to substantial bodies of persons or organized groups. So, his detention violates Article 9 of the Federal Constitution, which protects personal liberty. For the issues, there were three main issues. The first one is, was the detention valid under the law if he acted alone? And the second one, did it violate his constitutional right to the liberty? And then the last one is, did failure to follow constitutional safeguard make the detention unlawful? And now we touch about the legal principle. First, preventive detention law must be strictly followed because they restrict fundamental right. The court said the law only apply when there's a group threat, not individual. And the second one is the preamble of law. The purpose of it must guide how the law is used. In this case, it clearly states that the threat must be from organized group. And the last one is Article 9 ensure that the right to liberty and detention laws must stay within the constitutional limit. And for the court decision, the federal court ruled unanimously for the appellant. The first one is the detention under Section 6, subsection 1 was invalid because it wrongly applied the law to an individual. And the second one is it violated Article 9, his personal liberty. And the third one is the detention was unlawful because constitutional safeguards were not followed. In conclusion, the court quashed the detention, released the appellant, and made it clear that preventive detention laws cannot be applied arbitrarily to the individual. Thank you.